All right. Well, so we've got people getting on here, so let's get started. I just want to welcome everyone to the Marble webinar. I'm Marble Principal Attorney Jeff Pollak, and we're really fortunate to have Jacquelyn Khanich, one of Marble's managing attorneys for Texas, with us today to host this community Ask Me Anything Q&A session. Some of you might recognize me from previous webinars where I was in the hot seat. Fortunately, we've got Jack in the hot seat today, but I just want to thank all of those of you who provided feedback following our last webinar in June. Our goal really is just to make these as helpful as we can, and interesting, of course, and fun when we can. And so we're really just trying to incorporate the feedback we get. We really hope this is informative. People learn things from this, and so we appreciate everyone coming. Thank you for being here. I guess let's kind of go over the agenda. First let's kick it off. Let's see if we can move a slide. I think we're waiting for. There we go. So first thing we're gonna do is kick off with a few housekeeping things, a little bit about Marble, an introduction on Jacquelyn, and then we'll cover what a SAPCR is. That's short for Suit Affecting Parent-Child Relationship. After that, we'll dive into community questions that were submitted during the registration process, followed by a little time for some live additional questions from all the people who are attending. And then we'll wrap it up by selecting a winner for 25% off of legal fees with Marble, and then a few closing statements. First thing, just in terms of Zoom best practices that I want to go over. Look, for privacy purposes, your microphone and camera, they're going to remain off for the duration of the webinar. Questions can be asked via the Zoom Q&A function, which I think you should be able to find in the controls towards the bottom. We're going to ask that for your benefit, that you ask these questions anonymously by checking the Ask Anonymously box. And for privacy purposes, please avoid sharing names of parties involved with your case or any details that might specifically identify you, the person asking the questions. We're also going to be asking poll questions throughout this event. You don't have to answer, and it's going to be anonymous, but it'd be great if you do. And really, these poll questions are just designed. Usually they're related to things that Jackie's going to be talking about. And they're designed to just kind of poll the attendees and see how relevant it might be to the people that are actually with us watching today. Again, there's going to be a participant that's selected to receive 25% off legal services with Marble via Zoom at the end. And we're going to send along this presentation following the webinar as well. One final word before we get started. This obviously goes without saying, but I just want to make sure everyone watching and listening understands that nothing being said today should be viewed as legal advice that's applicable to any particular person's situation. Even if one of the questions that Jacquelyn's talking about today happens to be one that you might have submitted, every person's situation is unique. There are so many follow-up details that an attorney, whether it's Jacquelyn or me or anybody, would ask of you before being able to really give any true legal opinion that would be applicable to your specific situation. So I just want everyone who's joined us to remember that your situation is unique, and make sure you speak with a licensed attorney to answer any specific questions you might have. Now, just want to kind of give you some information about Marble. And for those of you that might not know much about us, Marble's a new kind of law firm that believes everyone everywhere deserves access to remarkable legal care. With a fast digital onboarding process, a flat fee upfront price with the option to pay over time, and a dedicated team of attorneys and case leads who put their clients first, we've reimagined legal services to provide people with an easier, transparent, and more human experience when they need it most. Marble's currently available in Texas, of course, California, New York, Florida, and Arizona, and we continue to expand nationally. And if you're looking for any more information, you can always visit our website at themarbleway.com. And without further ado, it's my honor and pleasure to introduce Jacquelyn Khanich, who is a sharp, enthusiastic, and determined attorney, licensed to practice in California, New York, and Texas, which is not an easy feat for anyone that's ever thought about becoming an attorney or is one. Jackie became a lawyer to instill faith in the legal system while upholding the notions and values of fairness and justice. Before joining Marble, Jacquelyn had her own practice for over 7 years with extensive experience in family law, most recently focused on these SAPCRs we'll be talking about today, the suits affecting a parent-child relationship. And when she's not practicing law, she enjoys spending time with her very cute 2-year-old son, Thor, and traveling. And a fun fact is she's been to 90 countries, which is very impressive. And if that's not interesting enough, Jackie's also an avid cook and was a Chopped champion on the Food Network in 2015. I'm sure some people here have seen that show. I know I have. One final thing before we kick this off. Look, as an attorney who's been practicing in the family law space for many years, and as a child of divorced parents myself, I really do know that for most people, even when things are friendly and amicable, being involved in any kind of family law matter, it feels scary and sad, and it fills so many people with anxiety. You know, in my experience, most of those negative emotions stem from there being just so many unknown what ifs. And the reality is that while it seems like the whole process is complex and it's complicated, and the details sometimes are, issues related to family law typically tend to be pretty straightforward. That's not to say good or bad, but they're pretty straightforward. And, you know, as I always say, knowledge really is power. The unknown always seems like the scariest place. So, you know, I just want to say I'm really happy that we're all fortunate enough to have Jackie here to try and demystify some of these family law issues for everyone. So, you know, I guess with that, are you ready, Jackie?
I'm ready. Thank you all for coming. I'm really excited to be conducting this webinar today. And, you know, when I first started in family law, I had no idea what a SAPCR was. So I'm really excited to be sharing with everyone, whether you know what it is or whether it's a novel term. I can't wait to jump right in.
Awesome.
So a SAPCR stands for, as Jeff earlier said, it stands for the suit affecting the parent-child relationship. And so this is where a case asks the judge to make custody, visitation, child support, medical support, and dental support order for your child. It usually pertains to unmarried couples, but you can actually file a SAPCR even if you are married, but have separated and you don't quite want to file for a divorce yet. You can file a SAPCR even if you are married. And some people ask whether it's the same as a paternity case. And no, it's not. What a paternity case is a paternity case asks the judge to make those same type of orders, but also establishing who the legal father is. So this usually happens when the father is not on the birth certificate, nor has he signed the acknowledgement of paternity at the hospital. So one of my pointers is before filing a SAPCR, be sure to have a handy copy of that acknowledgement of paternity on hand. And if you don't, you can always contact your local Bureau of Vital Statistics to get one. So there's two types of cases. You can have an uncontested case or a contested case. In an uncontested SAPCR, there's a done deal. Both parents are in complete agreement on every single issue, whether it's the parenting plan, who is going to have primary custody, the child support amount. You know, sometimes people will come into my office and they'll say, you know, everything where it's uncontested, everything's in agreement. I'm going to be primary, you know, he's going to be possessory. And I said, well, have you agreed on a child support amount? No, well, we're going back and forth. That's not an uncontested, that is a contested. And so in a contested SAPCR, that's when there is, you know, a disagreement on one or more issues. And just to be sure that in an uncontested SAPCR, there usually needs to be something called a waiver to be signed by the opposing party. Now, if you don't have the parent adjudicated, so if the parent is not, if the father is not on the birth certificate and he hasn't signed the acknowledgement of paternity, then you're not going to be filing a SAPCR. You're going to be filing something called a petition to adjudicate parentage. And this basically accomplishes the same thing as a SAPCR. However, it also determines who the father is, usually by DNA evidence. And just like a SAPCR, you can have an uncontested and contested petition to adjudicate parentage.
All right, so here is first, we're going to do polls like I talked about at the beginning, and should have popped up. There it is. All right, so again, you don't have to answer, but would love to see everyone's feedback. Here's the first poll. What is it essentially? What are you trying to learn? So your options are your best practices for co-parenting, and what's in the best interest of my child. What are my rights as a parent and my child's other parents' rights? Want to know what to know before starting a custody case and child support and its effects on co-parenting and custody, or is it something else? We'll give you a couple seconds here to just log your answer, and then it's gonna the results will pop up. Let's see. Okay. There. All right. So here's what we see. Pretty much across the board. I'm not going to read it out just for the benefit of time, but a real cross section. Jackie, it looks like there's a real cross section of interest, which doesn't surprise me. I don't know about you, but
it doesn't surprise me. Yeah.
All right, so let's kick into the community questions now. And the first one is from Christian, and they ask, how can I keep my kids if we're not married?
So to keep your kids, if you're not married, you either need to file a suit affecting the parent-child relationship, or an acknowledgement, or a petition a petition to adjudicate parentage. In Texas, the main test in determining who gets custody of the children is what is in the best interest of the child. So usually the main caretaker will get what is called primary custody or primary conservatorship, and the other parent will usually be the possessory conservator. So if there's no court order, both parents will have a legal right to possession of the child or children. So if one parent takes off with your child, refusing to return them, the police usually won't do anything without a court order. So that's why it's so important that you do have a court order in place establishing custody, visitation, access, and child support. So what are the steps in accomplishing that order? So what are the steps in filing a SAPCR or a petition to adjudicate parentage? First, you have to draft and file a petition and suit affecting the parent-child relationship. Next, you must have your child's other parent served with the paperwork. And here in Texas, they have the Monday following 20 days after they've been served. Now, if you can't find them, there are ways that attorneys can do motions for substituted service, but that can get really complicated. I would suggest definitely hiring an attorney to help you with all of this. And so if someone doesn't respond to the petition, then you can go to the court and ask for something that's called a default judgment. However, if they do respond, then that's when the court case really starts going. And then you may have to go to mediation, which I'll talk about later. And you may have to, go to a hearing in front of the judge. So what is the most likely outcome of a possession between unmarried parents? The most likely outcome, absent, unfit, either parent is unfit, the most likely outcome is something called a standard possession order. And that's where the primary parent will have the primary custody, and the possessory parent, the parent that has to pay child support, will have the child on the first, third, and fifth weekends from 6 p.m. Friday to 6 p.m. Sunday, every other major holiday, and they get 30 days during the summer consecutively. Now, one thing that many people don't know is that parents actually have the right for an expanded possession order, which is from 6 p.m. on Thursday to Monday morning, and a few more overnights per week as well. So if you are the possessory parent wanting to get more time, I would opt for that expanded schedule.
Awesome. Thank you for that, Jackie. Okay, I think we've got the next question from Dion. It says, if the father doesn't pay child support, do I have to let my child visit him?
The answer to this is yes. The custodial parent has a duty to obey the court order for visitation, even if the non-custodial parent cannot or will not pay child support. So just because a parent is not paying child support does not give justification of not allowing the other parent access to the child. Child support and visitation do not go hand in hand. The court can enforce its orders against either parent to pay child support, but they will have to file something called an enforcement action. And I would advise to contact an attorney to help explain the whole enforcement process.
Thanks, Jack. I'm assuming this is probably something that doesn't happen infrequently, that someone doesn't pay child support and you say, well, I'm not letting you see Johnny then. probably doesn't end up very good for the parent who's not letting the other parent see the child. Is that fair statement?
Yeah, it happens quite a bit. I mean, I see it happen a lot. And what happens usually if one parent is denying access is when they do petition to the judge will often order back visitation. So they might get every weekend for a year just to make up that time that they were denied access.
So yeah, it makes sense. Sorry to interrupt. Yeah,
so it's just important to, not to deny access unless there's an extenuating circumstance like the harm of the child.
Sure. And there is an avenue. It's not like you just don't get paid and then, oh, well, like there's an avenue, but you just need to make sure you always do the right thing.
Correct.
Okay, thanks for that. Next question is from Monique, who asks, what can I do when the other parent won't communicate? I assume won't communicate with me, won't communicate with the child. I don't know. Okay, well, let's do this poll first, though. Poll is, and it's not popped yet, but I believe it's whether you've ever been in a court dispute, there it is, where it was questioned if a communication was real. Like, you're saying a spouse never contacted you and the other side say, yes, I did, or something like that. Communication disputes, yes or no? We'll see the results here in a minute. That's good. I'm happy to see that 80% have not. 20% still not an insignificant number. And I would guess if in a bigger size group would probably creep up. I don't know if it would be the majority, but definitely creep up. Great. All right. So, but back to that question, which was, what can I do when the other parent won't communicate?
So there are plenty of apps actually that help facilitate co-parenting. And one of the funny things about apps is that, going off that poll, we used to really never see like fake communication given to the court. But now with the advent of all these apps and fake numbers and fake text messaging, it's happening more and more, I would say, within the last 2 years. So I always recommend using an app that actually helps facilitate co-parenting. My favorite is Talking Parents. It's an app that you can use with a parent. You can exchange messages. You can call through the app. You can share doctor's appointments and doctor's results and report cards. And you can talk about extracurriculars, and you can actually do their schedule. So all their appointments. So, if mom has daughter signed up for ballet and dad, wants to get her in soccer, they could put the soccer and the ballet practice in the app. So both parents are going to have access to that calendar. And it's a really great tool to use. And also App Close is another one. Our Family Wizard is great. And so if the other parent won't communicate, I would try to suggest to them like, hey, I know that we don't get along, but, in the best interest of our child, can we please use one of these apps, to better facilitate communication between the parents? And so if they say no, you probably will want to talk to an attorney about that to address it in court. I know a lot of judges here in Texas are requiring co-parents to use these apps, and a lot of judges are putting them actually in the order, and some even requiring the only form of communication is within these apps, especially if family violence is concerned. And one other great thing is that it preserves any evidence that you need to use in court without having to prove each and every single timestamp and date to prove the authenticity and the realness of the document. The judge will have access and be able to see exactly what both parents are doing to better assist in determining the case.
Awesome. Yeah, I'm a big fan of apps like these myself. I think sounds like you are too. I just think there's these built-in guardrails that exist when both sides know that this is a platform where you can't hide what was said, and it's verifiable and everything else. So I think it usually keeps people communicating in a way I think is good, which is respectfully. And I think it's a great thing. Good stuff. All right, next question. Let's see who it's from. This next question is from David, who asked, what can I do if my son's mom resigned her parental rights through a text message? What are some steps I can take to gain custody of my son?
So a parent cannot terminate or resign their parental rights via text message.
Okay.
I've seen it happen where they try to, but it doesn't fly. Many people say things in the heat of the moment. They're in an emotional state. So allowing a parent to terminate their rights in the heat of that moment does not serve the best interests of the child. And it has been determined by the Texas Supreme Court that it is in the best interest of the child to maintain continuous contact with both biological parents. However, there are some exceptions for, unfit parents, of course. So if your child's other parent has engaged in this behavior, I would definitely save the text message. Be sure to save it with time and date stamp. And you can actually use this in court to argue on your behalf for sole custody, for termination of parental rights, or if you're fighting to be the primary conservator, but it's not a foregone conclusion. And so in order to, again, to gain custody, depending on your situation, you'll either file the SAPCR, a petition to adjudicate parentage, or if there's already an existing order, you'll file a modification in suit affecting the parent-child relationship.
That makes sense. And I think maybe another thing that's not said here is it makes sense that you can't just terminate your parental rights through a text message, because I'm sure it's the same in Texas. I mean, all parents have an obligation to support their children, at the least financially. And so to just be able to say, I don't have to pay for my kids anymore, that's not going to be something that flies. Okay, next question from Derek. How do I co-parent when the other parent and I live in different states?
So one of the most important things that you can do with your kids if you live in another state is to maintain that regular, consistent communication with them. So plan to talk on the phone with your kids, whether it's FaceTime, Zoom, Skype, but plan a specific time with them. Don't just let it be convenient up to them, because their schedules, they have friends, they have lives. But if it's actually set, as a schedule, it's more likely to happen. And then you'll maintain that regular, consistent contact. And so again, utilizing those apps that we talked about are really great in, co-parenting. And it's a great tool also to have contact with the kids. And so top tips is doing everything you can to keep up that communication, and visitation is key to successful long distance parenting. Create a schedule that works for your family, stick to it. Take advantage of technology, like I said before, messaging, video chats, playing games with your kids, exchange little gifts whenever you can to show your children you care. One of the greatest gifts I've heard of is giving like stationery to your kids and write them letters and have them write you back. I mean, this is such an antiquated thing, and does anyone write letters these days? But it's a great way to have them have like a physical thing, and they can put it into a scrapbook, or they might want to put it on their wall. So it really shows that you care. And another thing is to consider unique visitation arrangements, such as like a longer summer vacation with you, or unique trips around spring break.
Awesome. Thank you. Yeah, not easy for the parents. I'm guessing if they live in different states, definitely not easy for the kids. So hopefully all the parents think about, I know there could be some frustration between you and the other parent, but boy, these kids are innocent. So let's, try to always keep that in mind. All right. The next question we have is from Philip, who asks, how do temporary orders work, and for how long do they last for? I'm guessing is the question, but I don't know.
So the focus of a temporary orders hearing is usually to maintain what's called the status quo. And that's the current situation, albeit like, unless there's, turmoil in the house, then they're not going to want to maintain the status quo. But usually it's to keep the kids with the parent that's currently the main parent that's giving, most of the care. They're going to want to keep the kid in the same school. They're going to want to put an order in place that won't allow the other parent to take off with the child. Because like I said earlier, without a court order, either parent can keep the child and refuse visitation with the other parent. And the parent will have to go through the courts to get a court order to have visitation of their child. And it happens time and time again. This is if you file for the SAPCR and you're scared if there's a flight risk of the child being taken by the other parent, I would go for temporary orders, because that way you're not at your final order yet, but that way you have an order in place if they try to refuse visitation of your child. And so some of the things that you can get in a temporary orders in a SAPCR is you can get that temporary conservatorship. So there'll be like a primary and a possessory parent. You can get visitation rights. You can get temporary child support, provision of health insurance. You can have the court make you, exchange financial information necessary to set child support. Although this is actually now, as of January 1st, it's required to exchange financials after 30 days of the answer. And those are called initial disclosures. So temporary orders don't really address those anymore. However, if the child is in immediate danger with the other parent, and you can prove this by affidavit and with evidence, then you'll need to file for something called a TRO, which is a temporary restraining order for extraordinary relief, and an order setting hearing for temporary orders. And so that way it can get in front of the judge within 14 days to try to get that immediate access to your child because they are in harm's way.
Okay, got it. And you tell me if I'm wrong, but I think the idea with temporary orders is they're temporary for a reason. Usually the court doesn't have all the information that's needed, and or the other side didn't have the opportunity to present their entire side of the story. But of course, we're most concerned about like making sure a kid is safe and everything else, but they're temporary pending like a full examination of the issue where both sides present all their evidence and everything else. Is that?
Yeah, I mean, I would say it's somewhat true. They do last until final orders are presented. However, temporary orders are the first time you are in front of a judge. So it's really important to put your best and strongest case on, because after a temporary orders hearing, the judge usually doesn't flip sides unless there's, evidence to prove contrary. Now, in one instance, they do flip is when a custody evaluation is ordered. So, a judge in temporary orders might just give one party primary just to stay in that school district. But then when custody evaluation comes in, putting the other parent as a better fit, then a judge will probably switch it. So it is really important that, you put a strong case on for temporary orders, and it is very similar to that of a trial.
Awesome. That's great information. All right, let's move on to the next one from Chandra, who asks, what are my rights as a mother being unmarried to their father? Can I refuse visitation? So what rights does a mother have if the mother's not and the father are not married? And can that mother refuse visitation?
So your rights as a mother depend on what rights you're awarded with an order in a suit affecting the parent-child relationship or a petition to adjudicate parentage. Most courts will have both parents as joint managing conservators, meaning they have the same rights and duties. We call them, in the legal world, we call them heads, eds, and meds. So you have these same rights to make, psychological treatment, surgical treatment, the right to consent to them enlisting in the Army, the right to consent to them getting married, the right to pay for child support, usually by one or the other party. So usually it's joint managing, joint rights, but you can have a judge that, awards one party exclusive rights to those heads, eds, and meds, or the exclusive right to pick the school, pick the home. And so before there is a court order concerning the child, you may refuse visitation by the other parent, but it really is not advisable. So this behavior will not be taken lightly in front of a judge, and you may be accused of parental alienation, and the other parent may be awarded more visitation due to back time. So if you decide to refuse visitation, you really want to be sure that you're able to demonstrate those extenuating circumstances, such as the fear of the safety of the child is in clear and present danger with the other parent, or there are threats. If the other parent has threatened to take the child out of the country or out of the state, that they're a flight risk. Those are some of those extenuating circumstances where a court may not look at you in the wrong light if you refuse visitation.
Got it. Again, I think the court's always looking at what's in the child's best interest, and keeping a child from their fathers sometimes might be and sometimes wouldn't be. So I think that should always be the guiding light, right?
Yes.
Okay. Next question is from Sarah, who asks, how can I have an unfair custody arrangement amended to be 50-50? So I'm guessing it's less than 50-50 at this point.
So Texas courts are reluctant to give a 50-50 parenting schedule. So if you want a 50-50 parenting schedule, usually mediation is the best way to achieve that, because most courts in Texas have deemed that it's usually in the best interest of the child to have a stable base with one parent, so they don't have to take their things back and forth every week and back and forth through extracurricular. So it has, a stable base. And I know that in California, that is contrary to California law. It actually is in the best interest to have 50-50 in California. So, here in Texas, 50-50 can work, especially with children under 5, because they're not in school yet, before starting kindergarten, because there's continuous contact between the parents. Like I said earlier, 50-50 is almost always achieved by agreement or mediation. And mediation is where both parties will usually have their lawyers and a third party, neutral, unbiased facilitator that helps both sides come to an agreement. And so one thing that's really important to keep in mind is that whatever is agreed to in mediation is binding, and you can't even go to the judge to change it. So whatever you sign is binding, and you have to remember that, because there's a saying that no one wins mediation because it's a bargain. So you really have to, be sure that what you're agreeing to is what you want. Now, if you want, let's say you want primary and other side offers you 50-50. I've been in a situation where a party was adamant that he wanted primary and did not take the 50-50 and ended up getting the possessory. And so sometimes, you should take the 50-50 if offered in mediation. So in this case, for the unfair, whatever that may be, custody arrangement, you'll need to file something that's called a modification in suit affecting the parent-child relationship. And so the question is when was this this person given that order, the unfair order? If it was within the last year and there hasn't been a material change in circumstances, a court is not going to modify the order. So in order to file a modification in Texas, there usually must be at least 3 years from the previous order, or a material change in circumstances, which can include either parent recently got engaged or married, either parent recently got a new job and they're more stable, one parent wishing to move out of state with a child, one parent becoming unfit to care for the child for some reason, such they're addicted to alcohol or drugs, or they've moved into an unsafe environment or home, or they've moved an unsafe figure into the home, or one parent, becoming more able to care for their child, often by overcoming those problems and obstacles that caused him or her to be a disqualified parent. So, people getting their life back in order can give rise to a modification to get more visitation and access to the children.
Or maybe like renting an apartment that now has more space than they may used to have beforehand. That's really interesting. Hearing what you're saying about this, it seems like it's pretty clear Texas has a strong policy of stability. So that's, as you said, very
one of the core values.
No, I see that. Interesting. Thank you. All right, I think we've got, if I'm not mistaken, I think we've got a poll here. There it is. And this one's another true false, which will relate to the next question, I think. But this poll, which will pop in a moment, says, I think, there it is. I live, true or false, I live within 100 miles of my child's other parent. Trying to get a sense of how many people have some decent distance, physical distance between the parents. A couple more minutes and a couple more seconds. All right, I think we'll probably close it here in a sec. Go.
Wow.
Interesting, Jackie. What do you think about that? Are you surprised that just about half of people live 100 miles away from the other parent?
I am surprised. I am.
I am too. On the other hand, I think that sort of distance can create so many problems potentially that, you know, you could almost see that I guess it can go both ways, but you can see how that in and of itself might create friction in a family law matter. Wow. Thanks everyone for sharing. That's really interesting. And it really relates to this question, which is from Daniel, who asked, how does visitation work if the other parent lives out of town, you don't live in the same place?
So Texas has a standard possession schedule for parents that actually live over 100 miles apart. This is actually contrary to California law because California doesn't have such a provision. So in Texas, there's weekend visitation. So the non-custodial parent, they can either exercise the normal weekend visits, which is the first, third, and fifth weekends, but often that's unfeasible, unrealistic, timely, and costly. So it's really hard to exercise. Now, if they have the availability to do so, they have that right. Now, what often is the case is the parent will elect to exercise 1 weekend per month, and it's of their choice, and it begins at 6 p.m. on the Friday, ending at 6 p.m. the following Sunday. And the parent that lives out of town has to give the other parent 14 days written notice, written or telephonic, on the weekend that they choose. And, you know, it must be made in writing, whether they opt for that election. Okay. So whether they want to do the first, third, and fifth, or whether they want to do 1 weekend, they have to put that choice in writing. And it has to be within 90 days of moving over 100 miles apart. And so let's say two parents live in the same county, and then one parent moves to another county. They have to let the other parent know, I've moved out of the county and I want to elect to have my child on 1 weekend per month. And they have to do that within 90 days. Now,
the person who's moved, the possessory parent, is the one that makes the election and has to do so within 90 days?
Correct. Yeah, they have to do so within 90 days. And one thing that I get a lot is that, you know, when parents live in, you know, different states or even sometimes different countries, they're like, well, you know, my husband hasn't exercised. He only exercised 2 of the 12 months, you know, and I want to enforce him to, you know, do what he's supposed to do. You cannot force a parent to exercise possession. You only have the right and duty to give up your child if they want to exercise possession, but they are not required to do those monthly visits because oftentimes people can't afford to do those monthly visits. So, you know, that's one thing that I do want to note. Also, if you do live over 100 miles apart, in order to compensate for all that time that you're missing with your child, Texas law gives the non-custodial parent from 30 days to 42 days during the summer, and they give every spring break as well. And so for the 42 days in the summer, the non-custodial parent must give written notice to the other parent by April 1st if they want to specify for an extended period. Okay, just for the period, if they want it, you know, that 42 days. And then by April 15th, they have to let the parent know what dates they're going to exercise during the summer. If they don't give an election to which dates they want, by April 15th, it's just going to kick back and the possession will start on June 15th at 6 p.m. through July 27th at 6 p.m. And unless the parents agree to a different pickup spot and drop-off spot, the child will be picked up from the primary parent's residence. And so this is pretty set in stone, and it's almost in every single order that I draft.
And this is considered standard from a Texas perspective, which, you know, you're licensed in California too. So different from how we would do stuff in California. Let me ask you a quick question. It's so interesting to me. So this decision of when the possessory parent, the parent who's not we would call it custodial, I guess, it's completely in their discretion of which days they want. The custodial parent can't say, well, those days don't work for me. It's the non-custodial parent just gets to choose. These are my dates.
They get to choose. Yeah, that's their right to choose. They can't say, oh, I have a vacation planned. That is their right. as a non-custodial parent, should be no objections. As long that it happens before or after school ends and before school starts. It has to be within those days. So if they opt to start it, on August 1st, and, school starts on August 15th, they can only exercise for 15 days. So
understood. But I guess on the other hand, if you look at it, it's sort of my philosophy, has always been my philosophy, is it's so much better for parents to find a way. Sometimes it's not possible, but to be able to find a way to communicate effectively, reach some agreement so that there isn't discord and fighting. And so vacations can be planned and people can know what's going on. Even well before April, I would look at this and say, boy, that's a real reason to advise a client, a friend, a sibling, a parent, hey, try to find a way to work it out, because it's better for the kids anyways, if possible. I don't know, but it's really interesting.
One thing I find really interesting as well is that even if the parents don't live 100 miles apart, they're going to put this language into every order. I've seen it. I mean, so it's the if.
No, big time. Now, let me ask you a question. Let's say you said here, they have this certain amount of time to designate this 90 days, and they get, to designate what the schedule is going to be. And then these 42 days, like you said, they don't have to, you can't force a person to take possession of their child during visitation time. But I'm guessing if a parent doesn't, maybe I'm wrong, but if a parent doesn't, and there's evidence of that, the records that are kept or something like that, wouldn't that probably be grounds to require more child support because there's just this child spending less time with the other parent? Or is that not the way it would work in Texas?
No, it doesn't work like that. California has an equitable distribution of child support based on the time spent with each parent. In Texas, there's no such provision. It doesn't matter how much each of the parent makes. That's another consideration that California takes into account. Here, it's set in stone. With one kid, it's 20% of the non-custodial's gross income. 2 children, it's 25%, and it's also reduced if they have other child support orders. But there's a graph, exactly what you're going to pay. You're going to pay health insurance, and even if like 50-50 is awarded, they still usually require one parent to pay child support. And so in Texas law, it is in the best interest of the child to have the stable home, and two, to be receiving child support from the non-custodial parent.
Got it. So really the only effect it could have, I guess, is if you're just not seeing your child very much, that could change the actual custody provision. So maybe that one parent no longer will be able to make decisions regarding that child's health or something, because they're just not having any involvement in the child's life, something like that.
Yeah, I would say if it's like gross neglect, not neglect as in, harmful neglect, but as they've never seen the child in 2 years, or, only one time in the last 3 years, that's grounds for, having one parent go for sole custody. But if that parent is making constant contact through FaceTime and using those apps and writing letters, they're really not going to take away those decisions from a parent that are trying to, effectuate a communication relationship with the child, but due to financial reasons, they might not have the money to afford to fly to Texas, to exercise possession.
Really, really valuable information. Thanks. I think we've got time for one more question, slide question, and then we will open it up for some Q&As. And if anyone wants to already start doing that, people that are here with us, by all means, feel free to start putting in some questions so we can get to them. So final questions from Tony. How difficult is it for a grandmother to get custody in Texas when the mother is unfit?
So in Texas, the Texas Family Code does allow grandparents to seek visitation and custody of their grandchildren, but the burden is on the grandparents to prove that it is in the child's best interest. And not only do they need to prove that it's in the child's best interest, they also need to prove that the denial of access to the grandparent would significantly impair the child's physical health or emotional development. And this burden is super strict. The standard is very high, and it's difficult to prove. And so there is a well-known grandparents' right case in the U.S. Supreme Court called Troxel v. Granville. And basically it held that grandparent access, they have to overcome this presumption that a fit parent acts in the best interest of his or her child. Now, there's been a last summer, there was recent Texas Supreme Court case that basically made it even harder than that, basically saying that it is in the child's best, and there's a parental presumption that it is in the best interest of the child to be with the fit parent. And so in order to prove that the parent is unfit, there has to be some really, really strong evidence to take parental rights away from a mother or father. And so time and time again, there have been some cases where we've met the burden, but, even in, I think I have a pretty good track record, but it's difficult to overcome. And I've, shed some tears and some big losses where I thought I met that burden, and, it just didn't happen. And so another thing that, you really have to take in consideration as a grandparent is that you're going to have to also not only have to prove the unfitness, that it would significantly impair the child's physical health or emotional development, you're also going to have standing. And standing is where you have actual care, custody, control, possession of the child for at least 6 months, ending not more than 90 days preceding the date of the filing of the petition, meaning the child has to have lived with you for 6 months consecutively. I mean, there can be some short breaks here and there, but let's say the unfit mother steals the kids back from grandma that's been taking care of them for 5 years, but they wait, 4 months to file the petition, there's no longer standing.
Sure.
So if you are a grandparent and you do have those unusual circumstances that you believe would deem the other parent as unfit, then you really need to get that petition filed within, 90 days of the other parent taking back the children. There is an exception to the standing rule. It is Family Code 10204, and it says that if the grandparent can illustrate that the child's present circumstances would significantly impair the child's physical health or emotional well-being, then the court may consider, dropping the standing requirement. But like I said, it's very, very hard to do so.
Yeah, and you can understand why. I mean, parents should have, as long as it's not dangerous for the kids. I mean, no, we don't have to like the decisions a parent makes, but if it's not dangerous to the kids, parent sort of has a right to decide pretty much whatever they want for that child. But at the same time, thankfully, if a child's health and emotional well-being are in jeopardy, then, who cares about a parent's rights? We need to make sure to keep an innocent child safe.
One thing I like to, encourage my grandparents is that, if I feel that they might not meet that burden, is instead of petitioning for having like sole conservatorship, is to petition for some visitation rights. And most often, a judge will award visitation rather than taking away custody from the mother or father.
Makes sense. Awesome. Thanks so much, Jackie. And we already had some questions roll in. So right now, we're going to answer some questions that the attendees, all of you listening, gave to us. This is live. Jackie does not know what these questions are. So this is the hot seat. You can continue to submit questions via the Q&A function. Just try not to share any details, and you should click I think there's a box that will say anonymous attendee. And if you don't know the answer on these, Jackie, that's okay. But I'm going to just hit you with them. Let's see here. Here's the first one. What can I do to make the other parent take a drug test for the safety of my kid? So parent is concerned that their other parent is doing drugs and wants to make them take a drug test because they're concerned for the child's safety.
So first, you're going to have to file either, your divorce, your SAPCR, your modification action. You're going to have to get the other.
You got to start it.
You got to start it there. Then you have to serve the other party, and you have to give them a chance to answer. After they answer, then you can file a motion with the court for drug screening. And it usually will require, sometimes some courts will have it by submission. So the judge will just order it and send out an order telling the other party that they have to submit to a drug screening. Usually you have to say, a reason why you can't, they might not give it just for requesting it, but you'll have to probably attach an affidavit saying like why a drug screening is necessary. And then you might have to set it for a hearing to show why a drug test is necessary. But you can't just file with the court like some people call me, they just want them to see if they're on drugs. There's no such thing as just filing to see if they're on drugs. So you have to start with a SAPCR, with a modification, or with a divorce in order to.
Do you also have to show that there's some reason? I assume people have rights to just not have to submit to a drug test no matter what. Maybe I'm wrong, but you have to be able to show, to get an order to make a parent take a drug test, you have to show, I really have concerns that this person may be under the influence of things. Or can you just say, I think so, and I want them to take a drug test?
It depends on the judge, depends on the court. So some judges are pretty strict about having reasons, and some will pretty much grant every motion. So it depends.
Isn't that the truth? You can have the same facts, same attorneys, same clients. You're in one courtroom, you get one result, go next door and you get the other. It's always a scary part of not coming to an agreement with the other side. You know, you don't get to take the final decision into your hands. Sometimes you can't, though.
Yeah, exactly.
Okay, so let me give you one other. Let's see, I get another one here. Can I move away, or do I have to let the other parent know? So I think, let me say that question. Is a parent allowed to just move away, let's say out of the county, without notifying the other parent first?
No, I mean, usually the court order, I mean, it depends on what the court order says. So if there's no court order, then the parent can do whatever they want. If there is a court order, if that order does say that the other parent shall notify the other parent of a move within, 2 weeks. However, this is one reason why I believe attorneys are so important in crafting the orders, is that, a lot of times when people just go to the Office of Attorney General, or if they'll do it themselves by some, online things, they won't put a geographic restriction. Okay. And so without a geographic restriction, the primary parent can move anywhere in the world with that child, because they have the right to determine the primary residence. So you always want to get, a geographic restriction put into your orders. And time again, you have a parent that moves without notifying the other party, but it's not contained in the language of the order, nor is there a geographic restriction. So it depends on what the order says. And that's why having a great attorney is really important. And another thing is that oftentimes people think that they can create a custody arrangement or agreement outside of the court, and they are not binding, they're unenforceable. And without going through the court process, you're not going to get an enforceable order or custody arrangement. Yeah,
I think the two things I think are really important, and I'd love to get your thoughts on it, unless it's pretty straightforward, and I think it is. And that is, when there's a court order on something, you need to follow the court order. And, I don't usually like to play good guy, bad guy in any sort of relationship, particularly if there's parents and there's kids involved. But if you're in the right on something, a great way to get a judge against you is to flip that and all of a sudden be a person that's not following court orders. Most cases, it becomes a credibility issue. The judge doesn't know anything. They have two people that are telling them two different things. How could these people even be living the same life? Their stories are so opposite. So you never want to put yourself in a bad light. And a great way to get a judge not feeling real good about you is that there's a court order and you choose not to follow it. So that's a great point, Jackie, which is the court order says you're not allowed to move out of the county without anywhere without notifying the other parent. You better do it. Of course, unless there's danger or something like that, but it's a really important point.
Yeah, that actually hits close to my heart, because I had a client that didn't follow a court order a few times, and the judge did not hold her kindly, and it was a big loss. And judge even said it's because she didn't follow the court order, and that's why he made his decision. So it's really important to follow those court orders.
It is. And sometimes it's hard to do because you're a parent and you feel you're in the right. And all of a sudden there's this outsider, this judge that's telling you, you have to do this and you have to do that. So I sympathize, and it's not easy, but boy, if you're not able to agree on it with the other parent, and that now a court's involved and they've told you what to do, you don't mess around. You don't mess around with court orders. It's just not advisable.
Yeah. If you want to have something changed in the order, you need to file modification. So
you do it the right way. And my philosophy always is always be the good guy, always be the person where you can go into court with really clean hands. And you're never going to be accused of not following an order or sending nasty emails. This goes into another thing. It's a little off topic, but I've always told clients, before you send anything to the other side, just ask yourself, am I okay if this text message or this email or this conversation, am I okay if this ends up as an exhibit in their papers one day? If the answer is yes, fine. If the answer is, I don't think it would be very good, don't do it. Write it, because it's good to get it out, and then throw it away. Exactly. And write it again in a way that you can answer, yeah, I'm good with that being an exhibit. All right, I think we probably got time for maybe one more. Let's see. How hard, I mean, this is just maybe an opinion, but how hard is it to modify visitation schedule? How difficult is it?
I would say, I mean, that's it depends. I mean, what are the circumstances? Why are you modifying? What are your change in circumstances? On difficulty, I always say there's always room for some modification, and whether it's a reduction in child support because now you have a new job, or, you want to get some more face time, even if it's not going to flip from primary to possessory, maybe not with the flip, but maybe you'll opt for the expanded, or maybe you'll get, more access, maybe you can get the judge to say, oh, I can have, 3 days a week for 30 minutes and a FaceTime call. So I don't think it's too hard to modify, but there needs to be a reason for it. You can't just get an order in place and just say, oh, I want to modify it because I'm not happy with what happened. You really have to have a reason to modify.
And there's a modification and there's a modification. So adding an extra phone call is technically a modification, or adding an extra day. But this is also a modification. I want to not allow the other side to see the children at all. And so, not all modifications are created equal. And I have no doubt the standards are very, very, very different. And I cannot believe that we have 1 minute left here, Jackie. But wow. I think we gotta close this up. I could feel like we could talk about this all day. Yeah, first thing I want to say that I want to say congratulations to Wendell G, who has been selected as the winner through the chat function. Wendell is getting you're getting 25% off of legal fees, and I see that you have received the message via chat, and we've got your email address. So thank you for that. And look, final note, I just want to thank everyone for joining, and you're going to receive an email with a copy of this presentation and the recording. We're always looking for feedback on how to improve these. So please fill out the feedback form in the email that you're going to get, and you'll get, and everyone who does will get 10% off of future legal fees with Marble. So anyways, Jackie, thanks so much. It's really, it was a pleasure being on here with you. And I learned a lot today, so I'm hoping that all the other people here did as well.
Yeah, thank you everyone for coming, and thank you, Jeff, for moderating. It was great. Thank you.
Take care, everyone. Have a great week.